So in this video, we will see about the arrest of the persons under section 41 to 44 of Criminal Procedure Code 1973. So these articles spelled about the arrest of a person. Apart from that, section 57, article 21, 22, 22 to 22 to 22, subsection 47. These are all also stipulates about the arrest, how arrest should be made and what are the procedures to be adopted while arrest. First we will see the in depth we will see the arrest. So first of all we see the nature and scope. So what is the definition of arrest, or why an arrest should be made? That is the nature and scope. Actually, arrest means confining a person is known as arrest, or the liberty of a person is extinguished, or the liberty of a person is not at his own spirit, or confining a person is known as arrest for the purpose of avoiding the person from escape of the police custody, or avoiding the person to commit furthermore mistakes or offences. For all these purposes, the arrest is made. So arrest means the confining of a person, or the liberty is at stake. The liberty of a person is at stake in arrest. These are all the meaning of arrest. And arrest by various people can be done. It can be done by the police, it can be done by a private person, or it can be done by a judge. These people are empowered to arrest a offender, arrest when a person make an offense. So arrest by private persons, because by the time the police arrives, there may be a great danger may happen to the public, or since it is a public wrong and there are wrong committed by the person is of serious nature, the public or a private person need not wait for the arrival of police. So they can make the arrest. That is spelled out in section 4 of the Criminal Procedure Code 1973. So whenever there is a serious offences happening in the presence of public, a private person can arrest or confine a person to avoid the person to do furthermore complication, to furthermore offences. That's why the power is given to the private persons. Then the third thing is, what is warrant? Warrant means a written order by the court authorizing the police to arrest a person, authorizing the police or some more officers to arrest a person. That is called warrant. Warrant is the written order by the court. So to arrest an offender, that is called warrant. And usually the warrant is given in case of non-cognizable offense. The warrant is given, or some serious offences the warrant is given. And even without warrant also the police can arrest a person. That is for the cognizable offence. For the non-cognizable offence, warrant is a must. The police cannot arbitrarily arrest a person. So the written order from the court is necessary. That is warrant. And next we will see how arrest is made. Arrest is made by three means. One is the police can arrest a person if under submission. So there is no resistance for the arrest of the police. So the offender is not giving any resistance or protest. And if at all, if there is any protest, and they may go for any the arrest can be made by means of force also. And the next thing, the from the custody also they can arrest the person. That is the arrest how made. It is in section 41 to 44. Sometimes to avoid the arrest, even the offender may run away from the scene, so the police can chase the person and arrest the person. During that time they can use the force also. Even they are empowered to fire the person, but not to take away the life, but they can fire the person in the leg and other places, so that without doing any major mishap to the or major harm to the person, they can arrest a person by using force also. That is arrest how made. So the arrest may be by and sometimes even the public help may also be sought by the police to arrest the person. These are all how arrest is made. These are all spelled out in section 41 to 44. And next thing, with regard to the arrest with warrant, this is under section 70 of Criminal Procedure Code. The provision has been laid down in section 70, for which form number 2 also should be given. In form number 2, that is the court authorities or the judge may give an order in form number 7 stating to arrest a person that with the name and what is the offence caused by that person. So in the form number 2, the warrant contains the name of the person to be arrested and what the offence he has committed. Those things will be spelled out in the in form number 2, and the provision has been laid down as per the section 70 of Criminal Procedure Code. Then even without warrant also arrest can be made. That is the provision has been laid down in 41 section 41 of Criminal Procedure Code in subsection 1. Without warrant also the police can arrest a person. Suppose if a cognizable offence has been committed by the offender, the police need not go to the court or go to the judge to get the warrant. So straight away they can go for arrest of a person considering the seriousness of the crime. Suppose in case of murder, in case of rape, in such of those cases, serious offences, if a person commits, then naturally the police can arrest the person even without warrant, considering the nature of the severe crime or seriousness of crime. That is, without warrant they can arrest the persons. And next thing, as per section 42, suppose if a person refuses to give name, sometimes they may apprehend the person and they may elicit some information from the offender. What are the offences? They may seek the name of the offender and also residential address and other thing. Suppose if he has given wrong address, or even if he has refused to give name and residential address and other thing, he has not disclosed his identity and all, then the police can arrest the person on this cause. That is under section 42. Then without warrant, as we already told you, by private person also, the without a warrant, the private person can entangle a person or can hold a person or arrest a person for the offences committed by a person which is of serious nature. So that is by private person without a warrant under section 43. Then by magistrate, suppose when a magistrate is on having chance to witness a serious offence, or in his presence the serious offence happens, he can straight away arrest the person because he is the authority for all these things. So by magistrate also the arrest can be effected. and implemented under section 44 of Criminal Procedure Code. Then another thing we want to tell you in this, the arrest of the woman. In case the woman committed some serious offences, it may be of dacoity or robbery, or sometimes serious offences might have been committed by the women, and being the feminine gender, some speciality to be adopted in woman arrest. That is, they cannot be arrested before dawn and after dusk. So before that means after 6 a.m. they can be arrested, and before 6 p.m. they should be arrested. So before dawn and dusk they should be arrested, and that too by touching the body they cannot. They usually in male, by touching the person the arrest can be made, by confining the person the arrest can be made. But in the case of women, the male police cannot arrest the women. Only the women constable can arrest the women, and if at all, if the arrest is to be secured for serious offences after dusk, then the concerned women police officer should obtain the order from the magistrate, who is competent to give power or order to arrest the women after dusk. That is with regard to the women arrest of the woman. But some yes, in this also, some, if at all, if the woman is having carried, or she should not be, some lenient view to be taken, and if at all, if the delivery, if she is full in pregnancy, some leniency should be given. That is the arrest of the woman. These things are to be adopted while arresting the woman. Then next thing we are going to see about the right of arrested persons. So the arrested person do have some rights, so that they can wield the rights, and they are, according to section 50 within bracket 1, the police officer should before arrest should tell the grounds of arrest, for what reason he is going to arrest the offender. That is spelled out in section 50 within the subsection 1 of Criminal Procedure Code. In section 50 subsection 2, the right to bail, the offender or the arrested person should be informed that he has all right to have bail, and he can approach the competent authority or the court authority to get the bail by means of supplying bond or security, like that. So that is the right to bail. And section 50 subsection 4, the arrested person should be produced before doctor for any serious injury in the body, or whether any deformity, or whether any drawbacks which they have, or medically whether fit to be confined or not, fit to be arrested or not, to be ascertained. For that, the police should take the person to the government doctor for the certification. That is spelled out in section 50 within bracket 4, and also section 54 also this has been spelled out. Suppose if the injury, whether the injury is caused, whether the injury is found on the body, whether it is before arrest or after arrest, are to be ascertained. These are all coming under medico legal cases. This is called MLC, medico legal cases. The legality is involved with reference to medical injury, that is injury caused, how injury happened to the detainee, that is the arrested person. These two to be certified by the doctor. That is the for section 54. According to section 56, the arrested person to be taken to magistrate within 24 hours of arrest. The arrested person should be taken to the magistrate for getting the custody of the person. He may be detained in the police custody or in the judicial custody. So to determine whether he has to be detained in police custody for interrogation or for interrogation in jail, that is judicial custody, these two things to be ascertained. That is, for that the magistrate should give the order for police detention or under judicial detention. And these things to be ascertained. These are the rights of the arrested person. The next thing, according to section 57, not to be detained for more than 24 hours. In police custody, the police is not empowered to detain a person for not more than 24 hours. Suppose if at all, if they are detained for more than 24 hours, they are breaching their rights and duties, and they are punishable for that, they are answerable for that. That is, they not to be detained for more than 24 hours as per section 57 of the Criminal Procedure Code. And according to section 76 of the Criminal Procedure Code, they are to be brought to court without delay, and they should also be brought to the court without any delay. If at all, if they have been ordered to produce the detainee or the arrested person in court, there should not be any delay in producing the person to the court. And section 151, as we already told, the detained person or the arrested person should not be detained for more than 24 hours. This is also spelled in section 167 of Criminal Procedure Code. Apart from this, there are some of the right of the arrested person under constitutional articles. Some privileges, some special things are given in constitutional article also. According to section 21, the life and liberty of the person should be protected by constitutional law. So there should not be naturally the life and liberty should be protected. That means there should not be any his life should be protected, and the liberty also should be protected. If at all, if they are arrested, they are bound. The police is bound to ascertain the reasons for which they have to say the reasons. And then section 22 subsection 1, right to consult the legal petition. Actually, the arrested person have the right to approach a legal practitioner for his release on bail. For that, the section 21 subsection 1 of constitutional law provides some provision, and that is, suppose even if an indigent person if he is an indigent person, he can also have the right to approach free legal aid also. Suppose if the arrested person for a week, if he has not approached for bail, then he can seek the legal aid of the legal aid, free legal aid. If he is an indigent person, that means poor person who cannot afford the money to the lawyer. That is according to section 22. And section according to 22 subsection 2, to be produced before magistrate. This provision has been laid down in constitution also. And then section 22 subsection 4 to 7, the right of detained under the pre-detention law, that is the detained right of detained under pre-detention law, preventive detention law. So he is under preventive law, detention law. So to prevent the some mishappenings from the offender, this has been the provision has been laid down. They can be arrested. It is preventive custody, preventive detention. It's called preventive detention. And then we will see some case study, 2 case studies also. That is, as per the inner meaning is, the police cannot detain a person for more than 24 hours. If they have detained a person for more than 24 hours, it is legally wrong and they are answerable for that. The action can be initiated against the concerned police. That is Joginder Kumar versus the state of UP, 1994, All India Report 1994, SCU 1349. In this, a lawyer was detained, a lawyer of age 28 years was detained for more than 5 days by the senior superintendent of police, Ghaziabad, which is in Uttar Pradesh. He has, without assigning any reason and without assigning any reason or contrary to law, he has been detained for 5 days. Nobody should be detained more than 24 hours in the police custody. So, and this has been held as wrong by the police. And then Article 21, according to Article 21-22, the Selvi versus State of Kerala, in this polygraph and brain fingerprint were taken involuntarily. So, under the guise of some mental disorder or something like that. So this is according to the violation of right. The right to privacy is violated according to section Constitutional Article 20, subsection 3. So the polygraph and brain fingerprinting taken is said to be as wrong because it is not a voluntary one, it is involuntarily taken and it is violation of right and violation of privacy. It has been held like that. So we have seen about the arrest, how arrest should be made, and what all the provisions for arrest. All these things we have seen in this video. With this we conclude this video.